responsibility along the supply chain. And today, this event is organized together by the Bolivian organization Senda, the Inter-American organization AIDA, by the Heinrich Böll Foundation, Colombia and Brussels, in collaboration with the European Greens of the European Parliament and German Watch. And I'm now heading over for the introduction words to Anna Cavazzini.
Yeah, hello and welcome everyone to this European Latin American webinar. I think it is really beautiful to have such a strong collaboration and such strong links. First of all, probably some housekeeping. So there is a Spanish, English and German interpretation. You can just choose with a little globe, usually in Zoom. And of course, if you have questions during the event, and we hope you have questions, you can post them in the chat. So we are here to discuss the question of how we can increase basically due diligence and also decrease the negative impact some activities of European companies might have in Latin America. And we am looking very much forward to the event, have an exciting new study that talks about exactly that. And afterwards, we're going to discuss this study on a panel discussion with several guests, basically from the European Commission, the External Action Service, but also from Latin American and European NGOs. And before I hand over to present the study, I would probably also give a short introduction from my side as an MEP, and also forgot to introduce myself at the beginning. So I work as a Green MEP a lot on Latin America, but also on due diligence. And of course, we in the European Parliament had been very excited that finally the European Commission proposed a mandatory due diligence legislation a couple of weeks ago. We in the Parliament had demanded for exactly that legislative proposal for years, because we see that there is a lot of problems of human rights violations and also environmental human rights violations in the global supply chains and also in Latin America. And I'm really, really very optimistic and positive that with this new legislation, the mandatory due diligence, but also actually the sectoral deforestation legislation, we will have some important tools in our hand to increase basically the responsibility of European companies and also in their supply chains abroad. Of course, from a green perspective, we would have had even liked to see some of the loopholes in the Commission proposals not being there. For example, the very blunt exclusion of SMEs, while we think there's also SMEs in high-risk sectors that could cause problems or that would need to be subject to due diligence obligations. Also, basically, the question of liability, where liability is really much limited in the Commission proposal, and so on. But I mean, I don't want to talk forever. I just want to give you a brief introduction, a political overview in which context we are holding this webinar, and hand over now either I think to Johanna or directly basically to the presenters of the study, and I'm looking very much forward to the results.
Thanks a lot, Anna, for this introduction. I'm very happy today that we can talk about environmental due diligence, and really, I'm very glad that we have some environmental due diligence in the proposal now, because I think environmental diligence is really important. First of all, to protect the environment, even if there's no direct human rights abuses linked to it, but especially also to prevent human rights violations. So I think it's I'm really happy to be able to talk about this today. And in this context, we did together a study with the authors that will present here together today, and also Pavel Aquino, an independent consultant from Colombia, from Peru. And today here, we want to talk, first of all, we want to present this study to show how environmental diligence could be implemented on the ground and what is actually needed to make environmental due diligence effective on the ground. So that's what our study wants to give an insight at, to see what what has to be looked at specifically to actually have an impact. And for that, I first of all want to introduce Andrés Angel. He is political scientist and geographist and works for the organization AIDA. Then we have Fabiola Vargas working for the organization Senda and accompanying communities in community monitoring. And we have Juan Diego Espinosa working for the Colombian Business and Human Rights Research Center, and having a lot of broad experience accompanying communities and helping to gather evidence. So here I want now to give the floor to Andrés to start the presentation today.
Thank you very much, Joanna. Can you hear me well?
Good.
Yes.
Awesome. So welcome everybody. So my name is Andrés Angel, as Joanna said, geologist specialized in public policy and working for AIDA as we did this publication. Right now, I'm also working for the United Nations University, and in AIDA, I'm doing the process of transition with the person that is now the scientific advisor. And in that condition, we wrote this report that we are going to present right now. So if we can go next in the slides, please. Great. I think 1 or 2 clicks, please.
Well, next slide, please.
Yeah, at least on my side is not showing. There we go. Thank you very much. So as Joanna said, this was a collaboration between AIDA, German Watch and Senda, and of course Powell, and also with the group of studies on extractivism, which is an initiative that AIDA launched last year, and it has to do with, gathering scientists and professionals of all areas that study extractivism in Latin America to support communities and the environment. Next. Yeah, so basically the context of this project is that there are new challenges. We are living very challenging times in all senses, right? So it's not business as usual at all. We have climate change, you have many new hurdles for development and for sustainable development. We have people that are still pushing for growth, although we are living in a finite planet. And we are seeing a lack of preparedness overall all across the table. And this leads, of course, to emerging environmental impacts, which also, in turn, leads to environmental conflicts exacerbation. And you have to remember that Latin America is the first region in the world, or the region with the most environmental conflicts tied to mining, for example, and extractivism in general. Next. Thank you very much. And I think a couple of clicks more, please. Okay, the first thing that you have to understand is that EIA and environmental due diligence are deeply interlinked. As you can see there, the OECD definition for environmental due diligence is a process that enterprises should carry out to identify, prevent, mitigate, and account for how they address these actual and potential adverse impacts in their own operations. And if you take into account the International Association of Impact Assessment, their definition of what an environmental impact assessment is a process of identifying the future consequences of current or proposed action in general. So they're pretty much very, very similar. They are not the same, of course. One is a process, the other one is, the result, the end result is the document that you present when you are proposing a project. So one has to be kept through time, and the other one is a one-time requisite, of course. There are other instruments that follow up in the environmental development of a project, but the EIA is presented at the beginning of a project. And if you have a flawed EIA, if you have a flawed diagnosis, that prevents from having environmental due diligence at all. That's the first thing I want to say. Next, please, or just one click. It is not, of course, a one-time requisite, as I told you, but it is also not, I think we are missing one click right there. Thank you very much. A palliative or a substitute when the impacts are unacceptable. So for example, if you have a project that is proposing, large scale mining, and it will generate perpetual water treatment, or you are not sure if it's going to generate perpetual water treatment, which can compromise the economical, social, and ecological sustainability of a country, that's simply unacceptable, and environmental due diligence cannot be predicated in such cases. So we have some issues in Latin America. I'm just going to quickly present them. They are more explained, in broad in the document, but I'm just going to quickly state them. So if you can click 4 times more, I think. The first one is the lack or flaws in independent analysis. It's very difficult for us from the civil society to have independent data. And I'm talking about biophysical and social data on the projects. Gaps in institutional assessment capacity. Our institutions are not ready to evaluate these kind of projects. We have slides for each of these examples, but we think that we are going to do a very short presentation so that you can input your questions. But we have examples on all of those if you are interested for the Q&A. Conflicts of interest, of course, the very people that are evaluating the projects are the people who are working in the companies, and this creates a revolving door that, it's very difficult to manage, and you cannot trust. Transparency goes off the window when you have such situations. Also, transparency and access to environmental information is very, very important. And that's not the case here in Latin America. It's very difficult to get the hard data. Of course, there are some initiatives, private initiatives, that advocate for transparency, but still we need to go to the next level, to have the data and to have the raw data so that independent academics, researchers, people in universities, in the civil society, elsewhere can have a say in this. Another really important thing that you have to understand here is that institutions and companies frequently confuse information and participation and social license for operation. We can talk a little bit more about examples of this, as I tell you, but I want to keep it short. So next. And of course, insufficient standards, which is something that my colleague Fabiola is going to talk about next. Next, please. Okay, please, 4 times more. And well, why does this happen? We don't have capacity building, there are knowledge gaps, institutional and procedural design flaws, and next. Financial resources, lack of financial resources, of course. We have proposals here, drivers of change and recommendations, we call them. So first of all, the concrete proposals for the European context are included in the environmental due diligence provisions in supply chain regulations. That's for the European Commission, of course. Perform mandatory environmental risk assessments throughout the supply chain. This has to do with the activities of the European companies elsewhere. Comparison of local environmental standards to highest available, that would be desirable, because we have very low standards compared to the United Union, to the European Union, to the WHO, US EPA, etc. And as far as I know, we can all get cancer from the same concentration of pollutants. So it is not acceptable that a child in Latin America is suffering a high concentration of whatever pollutant that there is. And there are, people more protected in other parts of the world. And these companies are operating in both. An institutional analysis, of course, you have to ask yourself if the local regulators are able to exert effective environmental control where the people or where you as consumers are buying raw materials. Next. Thank you very much. And finally, not to take much of your time, of course, there are some recommendations like support independent community monitoring initiatives in source projects. Fabiola is going to talk a little bit more about that. Provide legal assistance on the use of gathered evidence. That's very important because you want to have the community monitoring to gather legal evidence. And of course, relevant materials should be included in EDD regulations, especially in the batteries regulation. Next. And last one. This is the most important one. There must be a holistic approach in this. It cannot be part by part. We celebrate that there is like considerations on all the steps of the supply chain, but this needs to be taken into account in a holistic way because there are synergic and accumulative impacts. Thank you very much.
Buenas tardes. ¿Se me escucha bien?
Sí.
Muchas gracias.
Schönen guten Tag, hört man mich gut? Ja, danke. So, ich werde ein bisschen über gemeinschaftliches Monitoring oder das, was wir als unabhängiges Monitoring definiert haben.
Andrés, un paso muy
Wie
importante.
Andrés vorhin schon sagte, das ist ganz wichtig, um die Due Diligence einzuführen, muss man Umweltverträglichkeitsstudien haben, die gut gemacht sind. Und natürlich, wenn einmal ein Bergbau- und Minenarbeit ausgeführt ist, dann müssen wir auch konstante Monitoring-Prozesse haben, um zu sehen, welche Auswirkungen es gibt und wie man sie kontrollieren kann. Warum wäre es wichtig, ein unabhängiges Monitoring machen zu können? Dies sind einige der Gründe dafür. Einer der ersten Gründe ist, dass wir Aufzeichnungen haben über die Veränderungen, die sich in der Umwelt ergeben können, und wir generieren konstant oder ständig Informationen. Das ist ganz wichtig, weil die Leute der Community Zugang zu diesen Daten haben, und da es einheimische Leute sind, die seit langen Jahren in diesen Gebieten leben, so sind sie die Besten, die, sagen wir mal, die am meisten sagen können, wann bei Bergbauarbeiten und Minenarbeiten sich Veränderungen ergeben haben. Ein unabhängiges Monitoring versichert, dass die Communities hier selber mit diesen Daten umgehen können, das heißt, sie selber managen können, weil sie ja ortskundig sind und darüber auch sprechen können. Wenn dies aber nicht der Fall ist und keine Informationen über die Daten da sind, denn im Allgemeinen sind es Unternehmen, die selber die Daten vorstellen und dann auf eine solche fachliche Art und Weise, dass eine einheimische Person diesen Fachjargon gar nicht versteht, so dass es nicht zu einem horizontalen Dialog kommen kann, wie es aber kommen sollte. Aber auf der anderen Seite, wenn die Community selber diese Daten generieren oder erzeugen und schaffen, dann können sie auch ihre herkömmlichen Kenntnisse hier mit einbringen. Ihre uralten Kenntnisse, die überlieferten Kenntnisse, können sie hier mit einbringen. Und zuletzt das Allerwichtigste, dass wenn man ein unabhängiges Monitoring macht, dann können wir dazu übergehen, dass die Unternehmen verantwortlicher sind mit ihren Umweltauswirkungen. Nun gut. Wie funktioniert solch ein unabhängiges Monitoring? Ich werde von den Erfahrungen in Bolivien sprechen, die Erfahrung, die Sender gemacht hat, in einem Gebiet, dem Minen- und Bergbau umgesetzt wurde, in Popo. Und das Erste, was erstmal geschaffen werden muss, ist das Interesse seitens der Gemeinschaft wecken und dass es akzeptiert wird. Sind Sie mal einverstanden, dann können wir erstmal die Vertreter wählen, die Monitoring-Gemeinschaft, das gemeinschaftliche Monitoring machen. Dazu geben wir ihnen Verantwortung in die Hände und haben ein Engagement. Dann kommen wir zur Planungsphase. Das muss ebenfalls legitimisiert sein mit dem Rest der Gemeinschaft, muss akzeptiert werden von denen. Wenn wir das mal haben, dann können wir Daten generieren. Das Wichtige bei der Generierung dieser Daten ist, dass diese mit all den Akteuren geteilt werden können und damit Dialogräume um diese Daten herum geschaffen werden können und somit auch die Veränderungen sofort gesehen werden können, die im Laufe der Zeit oder die mit der Zeit aufkommen. All die Daten, die sich hier ergeben, müssen für viele Dinge nützlich sein. Zum Beispiel im Grupo haben wir den Fall gehabt, dass wir mit diesen Daten zum Beispiel auch Anzeigen erstatten können. Das hat dazu geführt, dass zumindest die Unternehmen, die dort in diesem Gebiet tätig sind, selber sich um die Dinge kümmern können und auch wo die Quelle der Einwirkungen und Auswirkungen. Oft sind die Gemeinschaften so an diese Auswirkungen, negativen Auswirkungen gewöhnt, dass sie das als normal ansehen. Aber bei den unabhängigen Monitoring wird auch ein Bewusstsein geschaffen. Welche Maßstäbe muss unsere Wasserqualität haben? Welche Maßstäbe müssen wir als Richtlinien und Prinzipien haben? Zum Beispiel, es ist doch nicht normal, dass mein Wasser zum Beispiel orange gefärbt ist. In Gebieten, wo Minen- und Bergbauteil ausgeführt ist. Also, dass man das versteht, warum, dass man die ganze Dynamik und das Drumherum versteht. Um diese Art von Verfahren oder Prozessen umzusetzen, haben wir gedacht, dass, oder Teil dieser Studie ist, dass es gewisse Empfehlungen gibt, ausgehend von 3 wichtigen Akteuren oder Darstellern. Natürlich die staatlichen Instanzen, die Institutionen in ganz Lateinamerika sind die am meisten hier mitwirken können, denn die sind ja für das Thema zuständig. Aber was wir auch gesehen haben, ist, dass die europäische Institutionen, europäische Kooperationsinstitutionen und andere Institutionen, die die Lieferkette begleiten, hier Teil dessen sein sollen und somit auch die Empfehlungen der Europäischen Union bezüglich der Lieferkette da hier auch größere Aktionen mit sich bringen. Eine der wichtigsten Akteure ist zweifelsohne die Anerkennung der Artenvielfalt, der Notwendigkeiten und Bedürfnisse, die mit dem Monitoring einhergehen. Wenn man ein gemeinschaftliches Monitoring durchführt, dann erfordert man Equipments, man muss von einem Gebiet zum anderen gehen, man muss technisch aus- und fortgebildet werden. Natürlich braucht man da auch finanzielle Ressourcen, die anfänglich von den Kooperationsinstitutionen gegeben werden können, aber die finanzielle Unterstützung muss nachhaltig gewährleistet sein. Es werden sicherlich Momente kommen, wo man mehr finanzielle Ressourcen erfordert. Deswegen haben wir gesagt, für diese Aktionen muss man immer an eine ständige Finanzierung denken und die sollte einhergehen mit Institutionen oder Behörden, die völlig unabhängig sind von den Unternehmen, die in Lateinamerika im Minen- und Bergbau tätig sind. Hier zum Beispiel hatten wir sehr viele Korruptionsfälle, und zwar wo ein Unternehmen bezahlt, damit gewisse Analysen durchgeführt werden. Aber wenn die Ergebnisse nicht gut sind oder nicht vorteilhaft sind für das Unternehmen, dann beeinflussen Sie auch diese Daten und die Ergebnisse dieser Daten, damit es dann doch letztendlich zu Ihrem Vorteil ausgeht. Also Transparenz und Klarheit dieser Daten ist ganz wichtig. Deswegen sollte die Finanzquelle unabhängig sein. Eine unabhängige Finanzquelle. Auf der anderen Seite wir müssen uns auch versichern, dass all diese Daten, dass man eine technische und wissenschaftliche Legitimität da ist bezüglich der Daten, sodass diese Daten akkreditiert werden, auch nicht nur auf kommunaler Ebene, sondern tatsächlich auch auf internationaler Ebene. Und zuletzt Es ist eine besondere Notwendigkeit da. Es gibt Reference Standards, das heißt internationale Standards, die verbindlich sind oder die sollen verbindlich für alle sein. Was passiert in den Ländern, die davon betroffen sind, dass die Standards immer sich anpassen an die Notwendigkeiten des Unternehmens. Hier in Peru hatten wir den Fall, wo ein klarer Unterschied zwischen den nationalen Standards und den internationalen Standards besteht. Und dieser Unterschied bezieht sich eben auf die Bedürfnisse des Unternehmens gegenüber dem Markt, und die sind dann nicht vertrauensvoll, oder man kann sich da nicht darauf beruhen, wenn es dann um Krankheitsfälle geht und so weiter, um wissenschaftliche Arbeiten. Vielen Dank. Vielen Dank, Fabiola. Juan, du hast das Wort. Bitte nächste Folie. Nächste Folie, bitte.
Tu micrófono está apagado.
Juan, kannst du bitte dein Mikrofon anmachen?
No te escuchamos.
Juan, wir hören dich nicht. Wir können dich immer noch nicht hören.
Maybe, Juan, maybe you can have check how it works again technically. And
Kannst du diesmal zuerst mal schauen, warum man dich nicht hört? Dann geben wir das Wort Anna Cavazzini. Und Anna Cavazzini wird auf Englisch sprechen.
Interlinked with human rights abuses on the ground as well. How can the proposal actually meet these needs or these problems? And what do you think the Parliament will go and propose? What changes do you see there at the moment, that the environmental issues are sufficiently covered, or do you see specific problems which probably will have to be added? Of course, the proposal is quite fresh and it's sometimes still basis for debate, but do you already have an idea on what you will be trying to change there?
Yeah, thank you so much, Johanna, and also thank you to the presenters. 2-3 remarks to basically what had been said in the studies. So the idea of including more materials in the battery regulation we had successfully done in the European Parliament. I don't know if you followed, but we managed also on our green initiative basically to include more materials in the battery regulation that will be covered then by the due diligence provisions. And of course, with the new horizontal law, it is horizontal because basically all the materials and everything all the products are covered, all the companies above a certain threshold. Let's put it like this. And this is, of course, good. And then the studies talked a lot about actually local capacity building and also support of local stakeholders. I think this is super important, and that shows also again that the mandatory due diligence legislation has to go hand in hand with also basically development cooperation, juridical human rights cooperation, that we need to have all or align all different instruments we have at the European Union level at hand, also technical cooperation in order to also support basically the obligations of the mandatory due diligence legislation. You also talked a lot about the monitoring. As such, it is, to my understanding, not included in the proposals. What is in that basically companies and authorities have to take into consideration also input from stakeholders and CSOs and the companies when they do due diligence procedures. So I think this is quite important, but I think for the end of the presentation of the study and also for the panel discussion, I think it would be really interesting to hear also from the NGO side or from the writers of the study on how exactly this monitoring can be included in the legislation, because to my understanding, it's not very strong inside at the moment. And very quickly, last but not least, Johanna, to your question on the environmental provisions, I think what is good that there is actually concrete environmental international conventions being addressed and being mentioned in the proposal. This was also a demand of the European Parliament, and that goes, for example, also beyond what we have on national level. For example, in my own home country, in Germany, where only 2 or 3, I think, very specific environmental conventions are being mentioned. So basically, this is already a big step forward. I think when you compare to some of the national legislation, I think what is still a blind spot for me, and this probably doesn't come to surprise for you, because I'm also working a lot on trade policy. I think also the international trade agreements need to be aligned and include more investors and company responsibility, and this is not yet the case. Yeah, so thanks so much for this super interesting presentation. As I said, I have to unfortunately leave, but I wish you a very good and successful debate.
Thanks a lot, Anna, for hosting this event as well. And one thing I think we heard from this presentation as well, and which we really hope the Parliament will take up, is, for example, water at the moment isn't really part of the proposal. Like, it's very difficult to protect water resources, and as we have seen, water is one of the main focus of community monitoring, one of the main human rights basis in the context of environmental human rights violations. So I think it would be very important to see that the annex also considers the environmental good water, just to mention one. I now, thanks a lot, Anna. And now I want to head over to Juan to make your final observations in regard to the study. And you've also already looked at the legislation, and you have some concrete proposals on what you think should be included there. And then we want to head over to the discussion together with the representatives of the EU Commission.
Muchas gracias, Johanna. Qué pena que tuvo un problema.
Ja, vielen Dank, Johannes. Tut mir leid, dass es mit meinem Mikrofon am Anfang nicht gleich geklappt hat. Können wir vielleicht die vorherige Folie, mein Name ist Juan Diego Espinosa und ich gehöre dem Business und Human Rights Resource Center an. Was wollen wir? Wir wollen hier zeigen, welche Garantien hier mit betrachtet werden, vor allem bezüglich der EU, und zwar was die Unternehmen angeht und ihre Lieferkette.
Según la base de datos del Centro de Información sobre
Laut der Datenbank des Business and Human Rights Research Center haben wir zum Beispiel Angriffe an Personen, die Menschenrechte verteidigen. Im Jahre 2020 ein Drittel dieser Angriffe waren gegenüber Personen, die die Auswirkungen, also negative Auswirkungen gegenüber der Umwelt- und Menschenrechte angezeigt haben, insbesondere auf Mangel der Information, der aktiven Teilnahme und Mangel an den Consultings, die hier, also überhaupt Informationen in verschiedensten wirtschaftlichen Sektoren. Also wir glauben, dass 10 Jahre nach der praktisch freiwilligen Due Diligence oder der Sorgfaltspflicht der Vereinten Nationen gibt es einige anwendbare Ergänzungen. Die ersten wichtigsten internationale Instrumente ist, dass erstmal die Personen, die die Menschenrechte verteidigen und Umweltrechte verteidigen, dass diese erstmal anerkannt werden. Zum Beispiel in der EU ist die Declaration und die Verteidigung dieser noch nicht mit einbezogen. Die nächsten beiden hat mit Empfehlungen. Und wie kann man diese Verteidiger der Menschenrechte und Umweltrechte, wie können wir sie schützen? Und dann haben wir noch eine Berichterstattung über dieses Thema. Und die letzten beiden Anmerkungen geht um die Zivilgesellschaft. Wie können wir seitens der OECD, aber insbesondere was diese Unternehmen, wie können wir, was die Gesetze angeht, was Due Diligence angeht, diese Personen diese Verteidiger schützen. Es gab hier 4 große Gedanken, und zwar, wie kann man durch Due Diligence effiziente Umwelt- und Menschenrechte im Rahmen der Lieferkette schützen. Wir glauben, dass die erste, die wichtigste ist, hat mit der öffentlichen Gebarung zu tun, und zwar um Risiken und Impact, sagen wir mal, überprüfen zu können, muss man immer adäquate Antworten haben, damit wir da ein Monitoring machen können. Aber es gibt auch andere Organisationen wie Protest, das ist das letzte Bullet Point, den Sie hier sehen. Die EU sollte auch die Risiken, die mit diesen Aktivitäten einhergehen, vor Augen haben und vielleicht ähnliche Standards haben, was diejenigen angeht, die diese Anzeigen erstatten, die diese Risiken entdecken und öffentlich machen. Und wir haben hier 2 Bemerkungen seitens der Interamerikanischen Konvention für Menschenrechte. Wir hatten hier große Sorgen bezüglich Klima-Impacts, die unternehmerischen Aktivitäten bewirken. Deswegen sollten wir die Konsequenzen des Klimas in den Providerländern auch uns anschauen. Denn von dort aus muss man auch zum Beispiel Verantwortung übernehmen, aber auf der anderen Seite muss man das Recht zur vorherigen oder vorgängigen Anhörung mit den Afro-Bevölkerung und mit der indigenen Bevölkerung muss garantiert werden.
Ja,
bis dahin meine Ausführungen. Ja, doch, kommt zu Ende, Juan. Ja, bis dahin, das ist mein Bericht, den können Sie jederzeit runterladen und wenn Fragen sind, stehen wir natürlich gerne zur Verfügung.
Thanks a lot for this presentation, and I think we have got a lot of more ideas, and I think it's very useful to look, if you want to go deeper into this, to look at the report, where of course we have been able to show it much more in detail and go into the arguments much more in detail. Also, we have thought about first things how it could easily somehow be integrated into the due diligence legislation, and I now want to head over to the panel discussion. And we have heard about a lot of problems about the lack of transparency and independence of data and the problem in the environmental governance. And all issues which are important to have environmental due diligence work well on the ground. And we have looked at specifically environmental impact assessments and community monitoring, and also what else should be included into the annex. And I now want to, first of all, I want to head over to Elke Winter-Maas to comment from her perspective what she she has been part as well of writing the proposal. So we have first-hand evidence here, first-hand insights on how the proposal came about and what it is actually now containing in regard to environment and maybe also in regard to climate, but focusing on the environmental aspects and to see what has been covered there. Also why, for example, in the annex only specific conventions have been covered and others haven't. And Elke Winter-Maas is legal policy officer in the corporate governance teams of the Directorate General for Justice and Consumers of the European Commission. And she's a German qualified lawyer by training, but has also previously worked as a lawyer in international firms. Welcome, Mr. Elke Winter-Maas. Mace, I'm very happy to have you here, and I'm looking forward to presenting the proposal to us in regard to environment.
Hello, everybody. Can you hear me?
Yes.
Great. So yeah, thank you for having me today. I already heard a lot of very interesting points that I would love to comment on, but we can do this in the discussion. Monitoring, role of stakeholders. There are many things to say about this. So let's take, but first of all, I want to start by briefly setting the scene as regards the Commission proposal on corporate sustainability due diligence, to explain the cornerstones and then focus, of course, on the topic of the discussion today, namely the environmental due diligence. So the Commission has adopted its proposal for the directive on corporate sustainability due diligence last month. And this proposal is really at the heart of the EU's values and political priorities. If we want to deliver on those important priorities and those ambitions, if we want to achieve the Sustainable Development Goals, we need to embed sustainable considerations in all layers of our society, not only at government level, but also at business level and at community level. And this proposal supports the shift needed at corporate level, because reaching these ambitious goals is not possible without changes in the business behavior. Companies, to become sustainable, need to improve their governance and their impacts in their global value chains. And so far, no EU country is on track to manage this sustainability transition. Only a small fraction is actually doing due diligence, covering the entire value chain. And it's not enough if front-runner companies change voluntarily, selectively, at their own pace. We need urgent systemic change and change of the mainstream across the EU. And when preparing this initiative, we have broadly consulted, and the interest was overwhelming. We collected nearly 500,000 responses from the whole world in the public consultation. And it was crystal clear what came to light. There's a wish and a need for action and for EU level action. There was also a strong call from the Parliament and the Council to take action. So now what is included? What is now proposed is a horizontal framework across industry sectors and a common denominator for EU companies, an EU standard, where businesses ensure the respect for human rights and the environment, not only in their own operations, but through their value chains in and outside the EU. And this duty is aligned with internationally recognized human rights and labor standards, and it is aligned with international environmental commitments. And I'll come to that in a minute. Businesses have to need to have in place adequate governance, processes, and measures to mitigate their adverse human rights and environmental impacts. And it's also about the tone at the top. The Commission thinks that it's important that also directors have the duty themselves to set up and oversee the implementation of this due diligence duty. And the process has to be embedded in the corporate strategy. So it has to really be the tone at the top. Just very briefly, you may have seen that there's, in terms of enforcement, the proposal includes public enforcement. So national supervisory authorities can impose sanctions, fines, and compliance orders, for example. And there is also, the proposal also includes a civil liability regime. Victims can get compensation if companies have not complied with their duties to carry out their due diligence through their entire value chain. So this proposal aims at a harmonized, ambitious, and balanced EU approach. So because unlike the existing voluntary standards, the UNGPs, the OECD guidance, this will be binding law with ambitious enforcement rules. And this balance between ambition and impact on the one hand, but also legal certainty in work implementability, so a workable framework, is key. And this balance can be seen throughout the proposal. Also when it comes to the environment. So what's in it for the environment? You will have seen environmental due diligence is included in this proposal. Companies have to identify, address, and account for the adverse environmental impacts in their entire value chain of established business partners. And also the civil liability regime applies in case a company has not complied with its duties and adverse environmental impacts incurred have caused the damage. So now the question that Johanna has also already asked is, which environmental impacts are covered? I would like to point to three elements. First, the obvious is the annex that lists a range of multilateral environmental conventions. This list in the annex includes conventions that are already, as Anna Cavazzini said, in the German supply chain law. But this list is larger, it is extended, it includes a range of additional multilateral conventions. So why are these conventions included? Those are the conventions included are multilateral conventions that are largely ratified and recognized worldwide. And those conventions included, they include precise enough provisions that can be applied directly by companies. So the approach is it's the same approach as when it comes to the list of human rights. The aim is to include precise obligations that leave clear obligations that leave no doubt at company level what is required from companies. There should be no legal uncertainty that would ultimately jeopardize the effectiveness of this proposal. So the second element that I would like to mention is the list. I would like to point to the list of human rights in the annex. This list the annex also lists measurable environmental degradation that leads to human rights impacts, so number 18. So the prohibition to cause measurable environmental degradations, such as harmful soil change, water and air pollution, harmful emissions, excessive water consumption, or other impacts on natural resources that would violate human rights. I would also like to point to other numbers of this annex, the prohibition to unlawfully evict and take land, forests, and waters when acquiring, developing, and otherwise use lands, including by deforestation, and the violation of the rights of indigenous peoples to the lands, territories, and resources which they have traditionally owned, occupied. So this is the second element that I would like to point out. The third element is the provision on climate change in Article 15. So to be clear, due diligence under this proposal does not cover adverse climate change impacts. So the Paris Agreement is not part of this, the environmental conventions listed in the annex. But there is a self-standing corporate duty that applies to the larger companies, the Group 1 companies. Companies have to adopt a plan to ensure that their strategy is compatible with limiting global warming in line with the Paris Agreement. This duty is subject to administrative supervision only. And such plan also needs to be part of the long-term variable remuneration of directors. Also briefly, let me point to the review clause in Article 29. So the due diligence can be possibly extended to climate impacts at a later stage. To conclude, I would like to stress that this EU framework will not stand alone. It will be complemented with accompanying action on the ground by the EU and by other actors. This is vital. It will also be complemented with sector-specific action that can be more specific and targeted depending on the sectoral risk identified. Anna Cavazzini has already mentioned the batteries regulation, the proposal. So, all of this has to be seen together. With this, I will now end my short intervention, and I'm happy to discuss these points and other points in our discussion. Thanks a lot.
Thanks a lot, Mr. Wintermeis. That's really good overview. Thanks for that. I think we can later on discuss a couple of points deeper. Also, I would be very interested in the issue of accompanying activities you mentioned, which maybe could also be trying to look at more what is happening on the ground and to strengthen that. But before we go further into discussion, I would like to give the word to Alejandro Garcia-Esteban, who is a Spanish qualified lawyer with experience in national and EU labor and social law and litigation. And since December 2019, he works as a policy officer at the European Coalition for Corporate Justice, where he has been working on the research and design and promotion of human rights and environmental diligence, one of the main networks at the European level following this legislation. So welcome, Alejandro. I would now like to ask you, from your perspective and the perspective from civil society, what you've been discussing in your network, where do you see the main weaknesses and main strengths of the law, and where do you think that hopefully the Parliament will take leave the ladder, higher the ladder, and the ambition? And especially I would like to ask you as well to maybe start off, as today we want to focus a bit more on the environmental issue, to talk about that as well. Thanks a lot.
Yeah, thank you. Thanks, Johanna, and thanks for inviting me on behalf of the ECCJ. I'll try to be brief because, well, in summary, the Commission's proposal on corporate sustainability due diligence is a step forward in advancing corporate accountability, but the problem is that it falls short of actually of UN and OECD standards on due diligence that we already had in place, and it falls short of some important demands of civil society, some of which we've been already discussing today here. It falls short by leaving certain gaps, certain holes, certain flaws in the text that risk limiting very much the impact of the legislation on the ground. And maybe if we are focusing on the environment and on environmental due diligence in particular, the first one that comes to mind has to do with the material scope of the directive. That means which standards does the proposal of the Commission oblige companies to ensure respect for? And in this regard, the proposal comes with an annex. And in this annex, there is a list of, on the one hand, human rights impacts, and on the other hand, environmental impacts that companies have to make sure to prevent and to mitigate. So while on the side of human rights, the list is rather comprehensive, still improvable, but rather broad and comprehensive. On the environmental side, we have only a narrow list, a narrow reference to certain articles in certain international conventions on the environment. And this does not provide for sufficient coverage of all the possible environmental impacts that companies might have or are actually provoking. So on the one hand, we find that there are some international conventions that are missing from the annex. But even if those conventions were included, the problem is that the body of international environmental law is by itself not sufficient enough. So we need a different approach when it comes to defining the environmental impacts that companies might cause, and we need a broader, different approach. We need a broader approach, one that, instead of referencing exclusively international conventions, also provides for a list of environmental harms that companies should check that are not happening or that they are not causing or contributing to. So this is a fundamental change to the material scope that should be made throughout the upcoming negotiations of the text. That on the side of the material scope. Another important point would be the value chain scope of the proposal. That means how far along the chain, how far along the global supply chains of companies are companies required to take action. And here, on the one hand, the proposal is rather ambitious when it doesn't establish any sort of tier limitation. It covers every potential tier of the value chain, both upstream and downstream, which is very positive. However, it introduces a very dangerous term, or a dangerous term that could risk limiting very much the impact of the legislation. It introduces this idea of established business relationships, meaning lasting, long relationships, so that companies only have to conduct due diligence over those business partners. And this, even though it's actually a bit unclear in the proposal, in our view, and after first reading of the text, this risks leaving out important relationships where severe impacts are actually quite likely: short and stable, informal working relationships, and that is a risk. There is the risk that companies neglect those relationships and only focus on the permanent, long lasting relationships. And one more issue about this is the fact that this limitation actually incentivizes or provides an incentive that is contrary to the spirit of due diligence. This limitation might actually lead companies to feel more tempted to switch suppliers more regularly, precisely to avoid creating those lasting relationships and avoid the obligations in the directive. So this is something we need to change, or we won't change throughout the upcoming negotiations as well. We need the directive to turn back to the UN and to the OECD standards and turn back to this risk-based approach that is in international due diligence standards. And that means that companies have to focus on the most severe and the most likely impacts, but that regardless of where the impacts are happening, regardless of how intense, how lasting, how strong, how permanent the relationship with the company that is causing those impacts is. And one more point on the proposal, two more points quickly that are very relevant to the topic we're dealing with today. One is the way due diligence obligations are described and defined in the proposal. Here we find that there is a major flaw when the proposal focuses so much and relies so heavily on the need for companies to obtain contractual assurances from their business partners and to have third-party auditors check compliance with those contractual clauses. That means, in practice, companies might feel tempted to focus on just including certain clauses in their supply contracts, in their contracts with their suppliers, and impose them compliance with human rights and with environmental standards, but without really taking a proactive approach, without really changing their business models at all, without really doing anything on their own other than passing down, shifting their responsibility down the chain. And this is quite dangerous. This is quite risky, this contractual approach to due diligence, because there is much more to it that companies can do and should do. And also evidence has proven that these mechanisms, audits, clauses in supply contracts are way inefficient, very, very inefficient, and have very limited impact on the ground. So that is something we also like changed. And just one last point very quickly.
We have a discussion later on as well. Alejandro, you can take up the point. Mention it briefly now, and then you can come up when you get the word again. So we come into
then the last point was about liability and access to justice, which positively is included. Civil liability regime is included in the proposal, but a lot is missing on addressing the barriers to justice that victims face in these kind of cases. And I leave it there.
Yes, and please go into it later on. Now I would like to give the word to Huiton from the External Action Service. And he is a senior trade advisor to the European External Action Service and chairs the OECD multi-stakeholder steering group on responsible minerals. And he focuses on due diligence in the supply chain and responsible business conduct from Brussels and global perspective. And he also monitors countries' performance on human rights and environment under the EU's general schemes of preference. And yeah, I'm really happy to have you here today because you have a lot of experience also from the accompanying measures of the EU regulation of responsible sourcing. And I would like to hear from you, how do you see the European Union could actually enhance measures like community monitoring? How could we strengthen communities in this regard to really have an effective implementation on the ground?
Dear Johanna, can I check if you can hear me, because I switched
can hear you
to
very
the
well.
microphone.
Very well, yeah.
To the headset. Mm-hmm. Well, thank you. I'll do a bit of trespassing on other issues as well. Let me just reduce a bit the speaker, so you can still hear me now. Yes. Well, our colleague from DG just explained what environment due diligence under the new directive entails for companies, but also for the EU member states. But more importantly, in this context, I think it's what are the implications for what we traditionally in supply chain due diligence call the upstream, with which I mean for local communities, local economic operators, but also for the governments upstream. And the directive, of course, there's work in progress by the co-legislator. Parliament and Council has a huge external dimension. And let me be clear, our legislation will have an impact, notably on the developing countries. Now, the objective of our legislation is twofold in a way. It's first of all leveling the global playing field for our companies, mainly by stopping what sometimes is referred to as a race to the bottom from a number of our competitors. And secondly, truly contributing to sustainable development globally. Environmental due diligence is not new. Let me just remind you. It's an integral part of the OECD due diligence guidance for responsible business conduct. And also, as we can see, for instance, the reference to indigenous people and prior informed consent, environmental due diligence is not separate from human rights due diligence. Just think of the right for the expert, the right to food or the right to health enshrined in the UN Human Rights Conventions. But I would like to recall, before we applaud too much indeed, that it is still relatively early days when it comes to putting environmental due diligence into practice. Just recalling that, what was it, 10 or nearly 11 years ago, when both in the Great Lakes region and at the OECD, we agreed on the due diligence guidance on responsible sourcing, not conflict minerals, responsible sourcing of minerals from conflict affected and high risk areas. Environmental impacts, environmental risks were not explicitly listed in the so-called Annex 2 risks. So it's 10 years may seem like a long period, but it is not. And only when we had the 2018 OECD horizontal due diligence guidance, which was approved at ministerial level, endorsed by industry, by civil society, cooperation with Latin American OECD members included, only then it was confirmed that for all to see that environmental risks are part of responsible business conduct. At this year's forum on the responsible minerals in May, the OECD will present the work, the state of play, on the new environmental due diligence tool, again demonstrating how relatively new this is. So this new tool work is ongoing, and this tool will set out how to apply due diligence to the environmental context, and publication, plus of course the obvious OECD working party and ministerial approval, is expected for the end of the year. And I will be also fairly honest, much work is needed so that the upstream adverse impacts, again, I'm focusing on the upstream and not what our companies will have to face downstream, but the upstream adverse impact, much work is needed before we can identify, address and mitigate these impacts by the companies, notably downstream. And for the environment risk, a complicating element, and we'll have to be conscious of that, will be that with a few exceptions, I think, for instance, the Minamata Convention on Mercury, there are very few international monitoring body reports with inputs by civil society, with inputs by trade union and governments, on which companies can and should build when implementing due diligence. So it's much more of of uncharted territories, which also links with the question by Johanna, that in many operating environments or surroundings, rather, not use the word environment here, it is not, and of course this is not about risk avoidance, this should not be about disengagement. So there has to be a strong role for on the ground monitoring. on-the-ground monitoring, in my view, and that's the experience from the minerals sector, is essential for many of the obligations which will be resulting from the directive, which are largely OECD guidance and ILO UN standards based. Only then, based if we have a solid baseline material, will we have better access to justice, more transparency, and genuine mitigation of the adverse impact, just to name a few. And I would say, luckily, our friends from DG INTPA, formerly known as DG DEFCO, Development Corporation, have identified supply chain sustainability as a priority for the just started or being started cycle of EU development assistance from 21 to 27. And one good example of this support from DG INTPA, which was on which they were the front runner, was the EU support to the European Partnership on Responsible Minerals, a good model for public-private partnership on responsible sourcing. Still, again, with the risk of sounding too negative, much work to be done also in making the directive implementable. Just look at Article 13 of the directive, the draft. Guidelines on specific sector or specific adverse impact. I think one or two speakers already referred to this. Article 14, the accompanying measures, helping inter alia joint stakeholder initiatives. From the minerals experience, this is not only essential, but this will take time. And of course, Article 15, the guidance for assessing the fitness of industry schemes or multi-stakeholder schemes, which we see industry cooperating with civil society to see if their alignment is real, if it's true, if it's only ticking the boxes, or if it really takes account of the impact on the ground. And just very briefly, a number of the takeaways from last year's forum on minerals and from the 10-year experience. Of course, we've seen more uptake of due diligence, but at the end of the day, to what some speakers refer to, a holistic approach is needed with good governance, with development assistance, and with policy coherence across the board. And due diligence cannot be a ticking the box exercise. So meaning inclusive due diligence, inclusive with civil society, and avoiding of de-risking. A lot of people speak about sanctions, about penalties, about civil liability. That is the end of the road. But much more important at the beginning is to get a good commitment on actually do this. And the thinking on due diligence now, of course, includes environmental and climate change, although less hard, the latter part under the directive. Meaning that how can we make sure that the company's longer term goals are about sustainability? And I would think the environmental wake up call also in the climate change fora made a huge difference. Again, a warning.
Please come to an end.
Yeah, very short. Most difficult issues is the cost sharing of due diligence. We have to make sure that the buck does not stop with the most vulnerable in the supply chain, be it artisanal and small scale miners or cotton farmers. And as was said, I think by several of the intervenants, which is very important, which is basically our company law, our due diligence legislation, can only be effective if we address also the challenges the EU and other economic operators face upstream when it comes to lack of governance. And due diligence legislation in itself is only part of the solution. At the end of the day, you need local regulators, you need local control, and people just highlighting this.
Please, Koos, come to an end.
Due diligence. Last remark. Just read the supplement on gold, pages 114 and 115 of the guidance on minerals. Of course, a front runner, but it does suggestions to governments, to funders, to donors, to civils, how to use local multi-stakeholder communities for actual checking and baseline. One of the most underdeveloped in terms of policies, and that's also a reminder to notably the European Parliament and the Council, one of the most underused appendices of the OECD guidance is hidden on page 114. Just read it. Thank you.
Thank you, Bruce. I hope that, I would have liked to hear a little bit more what we can do exactly onto the community monitoring. Maybe you have some time to then to go a bit more deeper into exactly this aspect when we have the closing comments in the end. But before that, I would like to give Andres one more time the word to comment what you've heard until now and what you think from your perspective is important to mention in this regard now, also what you think really has to be considered in the context of the process of this proposal getting into law.
Okay, thank you very much, Joanna. Well, I'll leave the community monitoring issue to Fabiola, which is the expert on that, and she has very interesting ideas that we have written in the document. So first of all, massively important points from Gus and Alejandro, and I would like to support those points. First, in terms of governance, you have to understand that governance here is a serious issue, and some of our countries don't even exert sovereignty in the whole of their territory. So we are starting from less than zero. It's very difficult in some of the countries. There's hope. There are things to do. We are building our states. We are developing countries, but we need to take this into account. The other point that Alejandro was making about mining impacts not being covered, that's really important. I also have the feeling that we are on the right track in terms of the principles. We are on the right place, but the appendixes of the supply regulation laws, especially part 2, they are, well, a nice declaration, but we need to be, and this is very, probably very scary for some, institutions, but we need to be prescriptive, and there must be standards, clear regulations, clear methodologies, recommendations, if you cannot provide, of course, prescriptive things for other states, because that's an issue, but at least recommendations, to establish commercial relationships with certain companies or certain states. That's very important, because if you leave room for interpretation, the ambiguity here in Latin America, and I guess in all Global South, always helps and benefits the polluter. Ambiguity helps the polluter. We need to understand that simple principle. And we shouldn't be afraid of addressing new concepts. We've been struggling to get the concept of perpetual impacts here in Latin America for quite a long time. And we've been replied with things like, oh, perpetual impacts don't exist. They are going to be solved by environmental management. And when you see such contradiction in the concept, it's absolutely ridiculous that you're saying that you can resolve perpetual impacts with environmental management, for example. We need to address the post-closure impacts of mining as well, and start conversations on what needs to happen in supply countries. You are legislators for the European Union. You need to understand what happens along the supply chain and what are the needs. That's very important. Another point is that climate change is essential. I mean, I cannot imagine a piece of legislation where climate change is not included. So it needs to be there somewhere. We are facing, a black swan with the Ukraine-Russia crisis, and we understand that there are pressing humanitarian issues, but also it is not acceptable that climate change has, disappeared from the conversation. And even in Germany, the conversation around coal is not getting so much attention as it needed, but especially in the countries like Colombia and other countries in the Global South that supply the coal, this has to be an issue. Geopolitics, of course, always to take over the most important critical problem that our species is facing right now, which is climate change. But we need to keep climate change in the room, because that affects the mining closure plans, that affects everything. All the planning of a mine project is affected by climate change, and this is something that has to be recognized and has to be dealt with. That's very important. Regarding batteries, I think that the perspective of risk categories is a very nice example of things well done. And we should also, look to incorporate other principles like the action plan of the United Nations Conference on Water, like the United Nations Water Courses Convention, and demand that companies comply with legal decisions and court decisions in our countries, and to strengthen grievance mechanisms. That's extremely important. The EU cannot have environmental justice in a country where human rights and environmental rights defenders are being killed every day. That's extremely important. So I would leave it like that. And with that, I assume Fabiola is next. Thank you.
Gracias, Andrés. Había una pregunta muy clave de qué se le puede pedir a la Unión Europea.
Was kann man denn in der Europäischen Union, was kann man dort anfragen oder verlangen? Tut, wir haben einige Ideen. Es ist ganz wichtig, dass diese Initiative institutionalisiert wird, vielleicht mittels gewissen Programmen. Zum Beispiel haben wir die Gründung
a scholarship program for people who would be willing to do monitoring, because
Warum? Denn schließlich und endlich ist es ja eine Dienstleistung, die der Community auch angeboten wird. Deshalb sollte diese Arbeit oder diese Aktivität auch anerkannt werden. Und wir sagten auch, dass ein freiwilliges Monitoring vielleicht auch ein Conditio sein soll, also eine Bedingung für Handelsbeziehungen. Ja, da würden wir auch das Finanzielle besprechen. Es gibt aber ganz wichtige Punkte, was die Institutionalisierung und Akkreditierung dieser Initiativen angeht, damit die Daten oder Informationen, die generiert werden, dass sie tatsächlich anerkannt werden in allen Instanzen. Dass sie so anerkannt werden, dass man dann sagen soll, wie können wir auch in einem Fall, in dem man zum Beispiel Anzeigen erstattet worden sind und so weiter, wie kann man diese Daten tatsächlich dann auch dafür einsetzen als Beweismittel, und sie müssen aber auch international anerkannt werden. Ja, vielen Dank.
Discussed that companies can should also downstream companies should try to provide funds. There should be the creation of a common fund also with downstream companies participating in that, being then administered independently and with participation of local communities, and that this data created in this can also very well be used by companies in the context of their risk assessment. And there are examples in the US already where data from community monitoring is displayed openly and can be used by companies to see, okay, well, there has to be more cautious, the pollutant levels are raising. And I think it can be very good complement also to audit processes, because it provides data on a more regularly basis, and it's not just a step into what audits mostly are, that just have a on-spot check and can't cover a long time frame. But as we have been talking now also how community monitoring can equip communities also to for right to access, right to justice, access to justice, I would like to hand over the word to Alejandro, because you had a point in regards to access to justice that you were not able to complement in your first round. So please go ahead on that.
Thanks a lot, Johanna. Yeah, I'll be quick. On this, going back to what I was saying, the proposal includes a positive provision on civil liability that would allow victims of human rights, or in this case environmental abuses, to go to court, and not just to their local courts, but to EU courts and sue an EU company that didn't comply with the directive, that didn't meet those due diligence requirements, and as a result, environmental damage occurred. So that is a very important provision that has been included in the proposal. However, there are a few elements that are missing there, and because they're missing, it will still be very difficult, very complicated for these claimants in this kind of cases of business-related environmental harm, to find remedy in European courts. Elements such as the heavy burden of proof that these victims typically bear in these kind of cases, which is not dealt with in the directive. Instead, the directive says that each member state will regulate this as they deem convenient, and there is no harmonized rules on burden of proof. in this regard, we think the directive should go further and should indeed harmonize burden of proof rules and be ambitious and require, specifically in the directive, require companies to bear the burden of proving what they can prove, which is not a big ask if you ask me, because in these cases it is always companies that have in their control the information of how they relate to the harm, whether they took all the measures or not to address the harm, etc., etc. So it should be them disclosing this information before courts and relieving victims from that burden of proof. And other barriers to justice, very, very quick, are, for instance, the narrow time limits to bring liability claims in some countries. We've seen cases of human rights, environmental damage where victims were prevented from accessing judicial remedies simply because they took more than 1 year to bring the case since the harm occurred. And this is especially concerning in this kind of cases, transnational cases, where it takes quite some time, as we can all understand why, for victims to understand the case, to gather the evidence, to find a lawyer, to come to Europe, to build a case, to bring a lawsuit. So this is another important element that the directive doesn't address. Collective redress mechanisms are also missing from the directive, a mechanism that does exist in the German supply chain law, for instance, which does entitle civil society and trade union organizations to bring actions on behalf of victims. So yeah, quite a few points there that should be improved to facilitate access to justice.
Okay, thanks a lot, Alejandra. And I want to make a closing round. And Guus, I want to give you, but really only 2 minutes. Please don't exceed, otherwise the others don't have any time anymore to comment. And I would like to ask you, especially focusing one more time, how we could really strengthen local communities in this context, so we really have an effective implementation, and yeah, how we can strengthen local communities to access data. And I think what we have now talked about access to justice, but I think also community monitoring is actually a tool to prevent the harm to come about, and I think that's crucial to consider. That it's even, yeah, it really strengthens the harm to come about. So maybe you could go into this, and maybe one point you hope that you think is important for everybody to take away, and maybe you think is crucial that it's maybe tackled by the other institutions coming now into the process.
Well, thank you, Joanna. It is, of course, difficult to assess what kind of actual framework one should be developing for community monitoring. I can only suggest at this point, because we're still early in the process of the directive, but it's clear that if you look at the appendix of the supplement on gold I just mentioned, for instance, it puts in not the obligation, but it suggests to governments, donors, and companies to make sure that local multi-stakeholder commissions from civil society, but also from industry, local and central government, for instance, to oversee the mine assessment process, setting up, I'm reading from the text, setting up teams from these multi-stakeholder commission to assess mine sites based on specific parameters, and having focal points for updating. All this comes with a cost. So I would suggest, and I know that there are companies that use information, whether published or indirectly, from community monitoring, whether at first juncture, whether we cannot have pilot projects under the EPRM. The EPRM is the European Partnership on Responsible Minerals. Should you have any problem getting in touch with the organization, please revert to me. If only we can get 1 or 2 project ideas in. I know personally that they're always hunting for good projects. What INPA will be funding in the future is much more of a long-term activity. And again, the contact with DG INPA or with our EU delegation in country concerns can help. So I would say try to get pilot projects in first and foremost by the I think try the EPRM, try other the format of our development funding, just to illustrate that it actually works and that it is essential. I'm not privy to what all our delegations do on the ground. We've had projects of responsible supply chain on minerals, which can use the same network I think we had 5 or 6 Latin American countries dealing with that those issues. So again, don't see environment as separate, see it as part of the overall due diligence, largely also human rights based. Thank you.
Yes, thanks a lot for that. And with that, I want to come to Elke Winter-Mees one more time and ask you, you mentioned different aspects in the graduate borders in the environment. How do you see, or how would you propose we could even this could be strengthened? Maybe that's difficult for you to say from your position, but I fear really that at the moment, water, for example, the risk of having the pollution and even taking away the access to water for local communities in the context of mining is not addressed by this proposal. How can we get this in? Because if we, how can this be tackled and how can we strengthen this issue, and why, for example, isn't the Ramsar Convention part of it? But maybe you can mention one aspect which you would have liked to be stronger in the proposal, if you can. That.
I mean, I can tell you that we've had many discussions internally about water. About the water question, also the Ramsar. I don't remember at the top of my head why we have not included the Ramsar Convention. I know that we've looked into it. I can now say what should be stronger in this process. This is the Commission proposal, but of course I understand your point. I've explained what our considerations were for including certain aspects in this annex. But I've mentioned these points in the human rights annex that tries to include water, excessive water use, and air and water pollution that has basic impact on human health. And of course, environmental degradation is a recognized human right if it impacts human health and local communities. So this is how we try to cover this. So it's difficult for me to now say what we should have done better. I probably don't have time. I wanted to make a point on the importance of this community monitoring, and I think that the proposal also gives space for this and recognizes the importance of stakeholder input. But I see that we're coming to the end, so I will now not make this comment anymore.
Yes, that would, of course, have been very interested. Maybe we can come back to you in this regard later, a separate discussion. Yes. And you can mention us where you see it. We can tackle it. Thanks a lot. I would now want to give a final comment for Andres, a couple of sentences and a couple of sentences for Alejandro, and then I want to say a couple of sentences as well, and then we're finished for today.
Okay, so then very quickly, yes.
Last thing to take away from this event and that has to be considered. Great.
So very quickly about the context information. It is extremely important when we are talking about community monitoring, the baseline. If you don't know what you have, you can know what you lost. Okay, so that's extremely important, and that's something that the companies play a lot with. If there is a faulty baseline or a baseline that they just made, then you cannot know what you lost because you never knew what was in there. Really, an extremely important the point that Alejandro made on the timelines of to do the reclamations or whatever. ICHR, for example, the Inter-American Human Rights Court, the timelines can span decades. So an environmental conflict can have, decades of litigation, and that's extremely important that the companies and the systems that regulate them, the commercial systems, understand this, because the timelines of the mining projects are as well extremely long. Sorry. It is extremely important that we strengthen the information systems. I mean, if benchmarking for us is that the communities know the environmental impact assessment, that's extremely poor for benchmarking. That's not even step 1. That's not step 0. That is something that is given. We need to have real victories, and real victories come with independent assessment, strong assessment, and that we can contest the information from the companies. Knowing the EIA, that's not a victory, and I'm sure that many private initiatives are working on transparency and providing information. We have IRMA, we have IEITI, and many others, but that's not enough, and especially not enough for people who are researching this, because sometimes you find the information in the sites that is managed, that is in bar graphs, or the mining cadastre is out there, but you cannot have the raw data. And if you don't have the raw data, you cannot do the analysis and you cannot help the communities. So that's extremely important for us to understand. And finally, my last point, and the main point that I want to make with this publication, is that a failed EIA, an EIA that fails to recognize the impacts of a project, prevents environmental due diligence. If you have a faulty EIA, if you have a faulty diagnosis, there is no environmental due diligence possible anymore in the life cycle of the projects. Thank you very much.
Alejandro, your last comment. What do you want the Parliament to take away from that? What should they definitely have? What do they definitely have to tackle? You've already mentioned a couple of points. What one more additional issue would you really want us to keep everybody in mind?
Maybe since I've already gone through our few major points, I will just add one to the list, which I think also helps wrap up very nicely this event, because it's linked to what has been shown, not just discussed, but shown in this event, which is the fact that communities, affected people, organizations, expert groups, there are a myriad of stakeholders that know what is happening on the ground, that are vigilant, that are tracking, that are checking, that are there and that know what's going on, and that companies should be engaging with. And I think stakeholder engagement is a crucial transversal element that should mark every single article of this legislation, and that should be at the core of the implementation of this legislation, and should be much further stressed and highlighted in the upcoming negotiations. At the moment, the proposal contains some wording about it, but it's still very weak and gives stakeholders a very limited role. But what we know and what we have also seen in this event is that there is, for the sake of everyone, for the benefit of everyone, there is a public interest in encouraging and promoting that much deeper stakeholder engagement, and that should be better reflected there. And that also links to the communication requirements that the proposal includes, which should not be just limited to formal reporting, but should also entail relevant, timely, meaningful conveying of information to stakeholders, to the groups, to the people on the ground, close to where harms are happening or potentially happening. So that I think we should add to the list of important ingredients of the whole recipe.
Thank you so much all for your time, Elke, for presenting the proposal to us and giving us the insight what was behind it and everything. Thanks a lot for that. Goose for you for mentioning what is possible, and from your experience, and Andres and Alejandro as well, from your experiences in this on the ground, and from the positioning in civil society.
Just if I may, one piece of advice: there's legislation, there's now the legislative process. You can still focus and use your influence in adding or changing For instance, Article 6, paragraph 4. It's about how companies can, should, or may use information in the first stage of identifying actual impacts. So if you think that things are missing or not, use your influence and reach out on the powers that be in Parliament and Council for Article 6.4 and other articles of the directive. Thank you.
Yes, I think for many, the work has only begun now with this proposal coming out, and a lot of really interesting months and maybe, yeah, hopefully month, let's see, to follow on this and then the implementation. So I think it was a really good start today to talk about this and to think about what could even strengthen this proposal more, and what has to be strengthened, and what has to be kept in mind. And yes, thanks a lot for everybody, and thanks a lot also for our panelists for sharing the study with us. You can all download the study if you are interested in the more detailed recommendations we made there, with the links which came together with the invitation. And with that, I want to close for today, and thanks a lot, everybody, and also to our audience, and yeah, looking forward to continue the discussions. Thank you.
Thank you for the invitation. Very good. Thank
yes.
Yes. Bye.
Thanks.
Bye-bye.
Bye-bye.
A good one.